questions. Senator Norris, the question I've got is over the statement that that it's improperly constituted. And my understanding of what we did in the Senate with your bill was to address a timing issue, which I think Senator Johnson brought up. I guess my question is, why do we assume that although the commission was constituted properly when it was at a time when there was a Democratic majority, that because of the change of the makeup of the General Assembly, that renders the commission improperly constituted? It seems to me that it was constituted properly under the statute that existed, and we kind of have a timing issue between two statutes. Is there an Attorney General's opinion or a legal opinion as to the statement that you made about that commission being improperly constituted?
Not that I'm aware of, Senator. The statement I made is just based on Tennessee Code Annotated 2-11-103, which says that 3 members of the commission shall be members of the majority party and 2 members of the commission shall be members of the minority party. Now, I know that there is, as you do, that there is authority for the proposition that actions that are taken when they are in a holdover capacity may not be suspect because they are holdovers, but that's slightly different than the composition issue, and particularly the clash of what's happening here. If this were not in sunset, if they had not already gone into wind down perhaps, and they were not in sunset, you might be able to say, well, we'll just rely on the holdover status. But you're presented with a very unique challenge here because they are in wind down and they are on the clock to sunset. And given that, your question is not whether the actions they have taken were appropriate as holdover appointees. Your situation is, given that the House seems unwilling to comply with 2-11-103, can you lawfully renew something that is no longer in compliance with the law? It's a slightly different question, but I'd given that some thought.
Well, the other question I've got is what the statute says it says. What it doesn't say is when you do it. And then we refer to another statute that says when you do it. And there's a time gap between when the majority changed and when the other statute says to do it. And it seems like a little bit of a leap to say because there's a time gap there that this commission is improperly constituted. That's my only point there. I don't see clearly that the makeup of the commission as it is now is improperly done. I do think that there's an awkward timing issue there, but I don't think it's improperly constituted.